Technical team, kindly make Justice MR Shah's co-host. Sir is unable to start his video. Marvi, am I audible? Make co-host. Hello.
Huh?
Sir, am I audible?
Sorry?
Sir, you are not visible.
હવે આવ્યો.
હવે આવ્યો.
Yes.
Yes, good evening, sir. Welcome, sir.
નમસ્તે સર.
નમસ્કાર.
ક્રિકેટ ટક્કર સર પણ 1 મિનિટમાં જોઈન થઈ રહ્યા છે.
મને
સર આપણી સાથે જી સર આપ ઓડિબલ છો? આપણી સાથે મિનિસ્ટ્રી ઓફ લો એન્ડ જસ્ટિસ થી અંજુ રાઠી રાણા મેડમ જોઈન हुए हैं. शी इज एडिशनल सेक्रेटरी इन मिनिस्ट्री ऑफ लॉ एंड जस्टिस.
Sir, good evening.
गुड इवनिंग डियर. अंजू जी कैसे हो?
Sir, I am fine, sir, with all your blessings, sir.
वेरी गुड. गॉड ब्लेस यू. गॉड ब्लेस यू.
Jan, kindly start the program. Thakkar sir is joining in 2 minutes.
Okay, thank you, madam. With permission of Honorable Mr. Justice M.R. Shah sir and Anju Rathi Rana madam, I would like to start the event. Good evening to one and all present here. I, Jayant Agrawal, as the anchor of this event, welcome you all in the 15 days online national capacity building program on legal drafting and pleading from District Court to Supreme Court of India on behalf of Sambhav Initiative and Pro Bono India. Today is our inauguration ceremony's first day, and we are privileged and honored to have such guests with us. Today, our inauguration ceremony will be graced by Patron-in-Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar sir, former Judge, Supreme Court of India, and Honorable Mr. Justice M.R. Shah sir, former Judge, Supreme Court of India, and Patron of Sambhav Initiative. And Sri Tushar Mehta, the Solicitor General of India, and Dr. Anju Rathi Rana Madam, ILS officer from Ministry of Law and Justice, Additional Secretary, Department of Legal Affairs. Before starting of the session, please follow some seminar etiquettes. I request to all participants to keep your microphone on mute mode during the session. In case if you have any question, then please use chat box or raise your hand. Now, I would like to invite Ms. Rujul to introduce the founder of Sambhav Initiative, Ms. Hiranshi Shah, for her welcome speech.
Ms. Hiranshi Shah is the founder of Sambhav Initiative. She is an associate member of the Chartered Institute of Arbitrators in the United Kingdom and a member of the World Mediation Organization in Germany. She is the first youngest certified mediator in Gujarat, certified under aegis of Ministry of Corporate Affairs of Government of India. She is also a young member of Singapore International Arbitration Centre, London Court of International Arbitration, International Council for Commercial Arbitration, and is appointed as conciliator in many national lok adalats for pre-litigation and pending cases.
Thank you, Rujal, for my kind introduction. Good evening, everyone. On behalf of the Sambhav Initiative and Pro Bono India, first, it's my honor to welcome our own patron-in-chief of Sambhav Initiative, Justice C.K. Thakkar, sir, and patron of Sambhav Initiative, Justice Emma Shah, sir. Under whose vision today, under whose vision and invaluable support and guidance, today we are able to organize this 15 days capacity building program. And not only this program, but we are also under his guidance able to organize and work on the overall vision of the Sambhav Initiative. I am also on delight to welcome Shri Tushar Mehta, sir, Solicitor General of India, and Dr. Anju Rathi Rana, ma'am, Additional Secretary of Ministry of Law and Justice, Government of India. Welcome, ma'am. I also extend my warm welcome to all other esteemed officials and board members of Sambhav Initiative, and also the esteemed attendees in this today's inauguration ceremony of 15 days online national capacity building program on legal drafting and pleading from District Court to Supreme Court of India. This program we are organized with aim to enhance the legal drafting and pleading skills for the law students and the practicing advocates. With that aim, we are planned over the next 70 days daily. We will get a knowledge from esteemed speakers, varies from the Additional Solicitor General of India to the former judges from Allahabad High Court, former judges from Gujarat High Court, former judge from the Uttarakhand High Court, Delhi High Court. They are also going to take a session daily, and they will provide their knowledge to the esteemed audience. Also, we have a keynote speakers from the advocate on record, advocates of the Supreme Court, as well as public prosecutors and additional public prosecutors from state of Gujarat, and also professors from the National Law University. They all are going to be our upcoming 17 days programs, wherein they are going to be speakers for this. So, and they were going to cover a broad spectrums of the drafting and pleading related to the District Court, High Court, and the Supreme Court of India, including the foundation of legal practice, case filing procedure, writ petition, appeal, and so and so. So, thank you everyone for being here to embark on this enriching journey with us. Thank you, everyone, and once again, welcome all of you.
Yes, Hiranshi, what is the further?
सर नमस्कार.
नमस्कार बोलिए. Everything is fine?
हाँ एकदम फाइन सर.
बस बहुत सरस बोलो.
अमन स्टार्ट. जयंत अग्रवाल.
Where is Jayant?
हाँ जयंत.
May be disconnected. Jitang, please take over.
Yes, Jayant.
You are not audible, Jayant.
Probably you are on mute. I don't know. There is no.
network issue लागे sir लागे. Network जी.
Maybe network problem. Now you are on mute. Yes. Yes, Mr. Agarwal.
Thank you, ma'am,
Yeah.
for the welcomes. Thanks.
Hello.
हाँ.
Yes. Yeah, we can hear you.
Namaste.
हाँ नमस्ते.
Brother
Sorry
Emerson,
for
you
technical
can
glitch.
hear, no?
Sorry. Yes.
Now
Sorry.
proceed.
Yes.
Jayant, proceed now.
Yes. Thank you, madam, for your welcome speech. Now, I would like to invite Mr. Rahul Kumar to introduce Dr. Anju Rathi Rana, madam, ILS officer and additional secretary, of Ministry of Law and Justice, Government of India. Rahul, over to you. Rahul, over to you.
I would like to take privilege and honor to introduce Dr. Anjurathi ma'am. Madam learned her LLB degree from DAV College, Muzaffarnagar, followed by an LLM from Meerut College, Meerut, and PhD in Law from MDU Rohtak, Haryana in 2002. With a career spanning over 29 years, Madam has demonstrated an unwavering commitment to justice and equality. Her notable achievements include pursuing the prestigious Lok Sabha Research Fellowship and receiving a nomination for membership on Android Governing Council. Additionally, she serves as a chairperson of Complaint Committee under the Sexual Harassment of Women at Workplace Act in the Ministry of Law and Justice. Madam began her legal career as advocate in Uttar Pradesh 1994. She became assistant public prosecutor in 1999 and progressed to additional public prosecutor in 2014. And in 2017, she was appointed as a joint secretary in the Department of Legal Affairs, Ministry of Law and Justice, Government of India. Since 2022, she has been serving as an additional secretary in the same department. We are honored to have you, ma'am. Over to you, ma'am.
Thank you, Jayant. Thank you, Rahul. Respected dignitaries, Honorable Mr. Justice C.A. Thakur, former Judge Supreme Court of India, Honorable Mr. Justice M.R. Shah, former Judge Supreme Court of India, Shri Tushar Mehta, Learned Solicitor General of India, esteemed colleagues, distinguished participants, and dear friends. It gives me immense pleasure to address this gathering at the inauguration of 15 days online National Capacity Building Program, Legal Drafting and Pleading from District Court to Supreme Court of India in English language, organized by the Sambhav Initiative and Pro Bono India. In the dynamic and ever-evolving field of law, the ability to draft and plead effectively is not just a skill, it is an art, a cornerstone of advocacy and a defining element of a lawyer's professional journey. Whether one is at the threshold of their career in the district courts or has ascended to the hallowed halls of the Supreme Court of India, the principles of precision, clarity, and strategic thinking remains paramount. In recent years, under the visionary leadership of our Honorable Prime Minister, Shri Narendra Modi ji, there has been a concerted push towards simplifying laws to make justice more accessible to the common man. The simplification of the legal process is not just a policy goal, it is a moral imperative. Access to justice should not be a privilege of the few, but a fundamental right of every citizen of India. As lawyers, we play a crucial role in this mission. Our ability to draft clear, concise, and effective legal documents is essential in breaking down the barriers that often alienate the layperson from the legal process. This responsibility places an extraordinary demand on our ability to communicate legal arguments with clarity and conviction, and to craft documents that withstand the scrutiny of both law and logic. Honorable Prime Minister has also emphasized the importance of ease of living and ease of doing business. And at the heart of these initiatives is the principle of ease of justice. By demystifying legal procedures and making them more transparent, we can bridge the gap between the judiciary and the people it serves. I firmly believe that this program will equip everyone with the tools to do just that. I am informed that over the next 15 days, you all will be guided by some of the finest legal minds in the country. These mentors will not only teach you the art of drafting and pleading, but they will also inspire you to think critically about how the law can be a force for good. They will challenge you to find ways to make your arguments not just legally sound, but also accessible and relatable to the people you represent. They will share with you the nuances of drafting various legal documents, be it pleadings, petitions, appeals, or written submissions, ensuring that you are equipped to navigate the complexities of the Indian judicial system. Moreover, this program is not just about learning the mechanics of legal drafting and pleading, it is about understanding the strategic considerations that underpin every successful case. It is about knowing when to emphasize certain facts, how to interpret legal precedents, and how to persuade the court with cogent reasoning. These are the skills that distinguish a good lawyer from a great one. I encourage each of you to fully immerse yourselves in this program, to ask questions, to challenge assumptions, and to engage in discussions that will enhance your understanding of the law. Remember, the true measure of your success in this field will not be how much you know, but how effectively you can apply that knowledge to serve your clients and contribute to the cause of justice. As we embark on this journey together, I would like to extend my gratitude to Sambhav Initiative for organizing this program and to the esteemed faculty members who will be sharing their wisdom and expertise with us. I am confident that the knowledge and skills you gain over the next 15 days will serve as a solid foundation for your future endeavors in the legal profession. Thank you, and I wish you all a fruitful and enriching experience. Jai Hind, Jai Bharat.
Thank you so much, ma'am, for your kind words and also joining us today, even in your busy schedule. Thank you so much, ma'am, once again to join and support this initiative as well as all over this program. Thank you, ma'am. Now moving ahead, today's our other special guest is learned Solicitor General of India, Tushar Mehta, sir. But today he's unable to join this inauguration program due to urgent meeting called by the Home Ministry regarding the Kolkata matters. But he sent his best wishes and regards to participants and also the Justice M.R. Shah sir and Justice C.K. Thakkar sir. So now we are moving ahead. Now I would like to join to go ahead with this.
Jayant, again, you are not audible.
Namaste. Thank you for your speech, Anju ma'am. I would like to know you all that Anju ma'am was a special PP and in CBI. She has a vast experience in the field of law. And in our this session, more than 800 people registered from 15 across in India, 15 states. Now, moving further, I would like to invite Mr. Jitayu Yagnik to introduce our today's special dignitary and patron of Sambhav Initiative, Honorable Mr. Justice M.R. Shah, sir, former Judge, Supreme Court of India. Jitayu, over to you.
I am extremely delighted to introduce the beacon of legal profession, whose name itself is an introduction to our legal fraternity, Justice C.K. Thakkar. Justice C.K. Thakkar retired from the Supreme Court of India. Sir was born on 10th November 1943 in Mandeh near Porbandar, Gujarat. After taking primary education from Mandeh and Madhavpur, Justice Thakkar graduated in law from Jamnagar. He also obtained a Master's of Law from Gujarat University. Sir began his illustrious practice in Gujarat High Court since 1968, and he was elevated as an additional judge of Gujarat High Court on 21st June 1990. Further, Sir served as the Chief Justice of Himachal Pradesh High Court and also as the Chief Justice of Bombay High Court. Sir was elevated to Supreme Court of India on 7 June 2004. Sir has also served as the Governor of the state of Maharashtra. We are privileged to have him as patron-in-chief in our initiative, and Sir has been always a constant support and guiding light to us. I would like to invite Sir for to say certain words on this event.
Thank you. My esteemed brother, Mukesh Bhai Shah, Mr. Tushar Mehta, who is unable to attend this function, Anjuji, Hiranshi and her team, I must congratulate you for taking this attempt and this exercise so far as pleadings are concerned. Before few days also, it was in relation to pleadings in relation to trial courts and other courts in Gujarati. And there also it was, I thought that it was very successful and it was really very much necessary. On my part, I may say only one thing, that I am coming from a small village and nobody from my family was a lawyer. So I had no idea at all about legal field at all. I did my LLB with good marks, fortunately. And then my professor wanted me to start practice only in the High Court. And that is how I came to High Court directly in Ahmedabad. And it was the first time that I saw Ahmedabad city also. It was only with a view that he was giving me advice, and I could not say no that I came here. All right. Now, as far as LLB level is concerned, I was having first LLB and second LLB. Procedural law, civil procedure, very important provisions, very important codes. Civil procedure, criminal procedure, Indian Evidence Act, Court Fees Act, Suit Valuation Act, nothing was taught to us. Pleadings and nothing. But fortunately, at that time, we were having chambering and bar council. And bar council examination was there. So some lawyers from practicing in the High Court, they used to take lectures and imparting us education also as far as as far as the students who had completed second LLB and they want to start practice. Now, it is really a very important part as far as pleading is concerned. You must have come across and you will come across in future also that if there is no pleading, since Privy Council, several years before Privy Council has said, you cannot lead evidence also. So I would request all junior advocates to keep in mind these fundamental principles. And those fundamental principles you will find in Order 6, and of course, other books are there, but Order 6 of Code of Civil Procedure, which relates to pleadings, plaint, written statement, etc., etc. All advocates and all students must study them carefully. You must keep in mind that all points must be taken. As far as your cause of action is concerned, you will put it, what has happened, facts must be stated, and essential facts in concise form and without entering into merits or without entering into evidence. As far as evidence is concerned, it is your prerogative and you need not disclose to the other side. But you must come with clean hands. You must say as to how the court has jurisdiction, as to how the suit filed by you is within the period of limitation. If there is, say, for example, some provision with regard to notice, because several statutes provide that before filing a suit, notice must be issued. You must be aware, at least Section 80 of Civil Procedure Code. But apart from Section 80, under the relevant statute also, it provides for notice, etc. Then you must say, if you have not given notice, then you may also justify your action. That for the foregoing reasons, it is not given. Or sometimes you want urgent interim relief and you may say that I have not served, I have not issued notice, but due to these circumstances, I want urgent and interim relief. If you are defendant, normally you will take all defenses. But I may say that it is not. No, sometimes it is said, it is denied that plaintiff is a plaintiff, and these are not, this will not help you, students. You must you must find the points which have been raised by you has some considerable substance. Say, for example, there is something with regard to limitation. You may say it is not within the limitation. If the court has no jurisdiction, you can say that the court has no jurisdiction. Because you are aware that jurisdiction is also of various kinds. Jurisdiction, pecuniary jurisdiction, territorial jurisdiction, jurisdiction as to subject matter. So you will take them. Any misstatement, wrong statement, false statement, or other than what is stated in the record, you must take and exploit the situation by saying that this is not correct. Particularly when you will be teaching and you will be saying about this writ petition also, you must be aware that if there is suppression of fact and if such fact is material, then the court may not enter into merits of the matter. So keep in mind that you come with the court with folded hands and true and correct facts. Therefore, in my submission, it would be very appropriate that students will take care of such situation. Then, with regard to judgments also and law also, first of all, you must study the law, legal provision to the utmost satisfaction of your client and to your satisfaction also. By and large, it is said that as far as Code of Civil Procedure is concerned, as Justice Chagla has said, the more you study the law, more you realize that how an admirable piece of legislation it is. So it is said that it is Gitaji, civil courts Gitaji. Now, if it is so, you will take into account and you will study it properly. I don't know now, but when I was doing my chambering, at that time, some books were also there, particularly very well-known book of Mogha. Mogha on pleading was there, then Bindra on pleading were there, and then some English book, Bullen and Leak and everything. But you must read at least fundamental principles of pleading. Then when you are filing an appeal against or some order, etc., you will take into account what is stated in the law. Say, for example, Section 96. 96, you must be aware that it is rehearing of the suit. You must have come across this expression also. First appeal is rehearing of the suit. So everything is available to you, question of fact, question of law, and mind well, as far as civil procedure is concerned, civil procedure recognizes only two principles, question of fact and question of law. But judicial side, it is said questions of fact, questions of law, and mixed questions of law and fact, res judicata, limitation, and all those. You will take into account all those circumstances and all those cases and try to help your client by putting everything. Then with regard to judgment, that also now obvious. Fortunately, you are having, say, this WhatsApp and everything is available. When I started practice, and probably Brother M.R. Shah or Tushar Mehta started practice, that was not the advantage with us. And in fact, we used to see quinquennial digest, then 50 years digest, then AIR manual, and several other such issues. But now, fortunately, it is available. And I think that you must exploit that situation also and try to put everything before the court. And mind well, very lengthy arguments may also not help you. The reason is that ultimately a judge is also a human being. And when you continue repetition, I don't say that consciously, but even unconsciously, sometimes the judge is bored. And thereafter he may say, all right, yes, okay, anything else? So try to be precise, and in precise form, if you put, then in my opinion, it will help you. You may succeed, you may not succeed. That's a different thing. But ultimately, we are legal fraternity. And at present, I am saying that we are lawyers. So when you are lawyers, you know that one party is going to lose. And as far as judges are concerned, on judicial side, it is stated that a judge who has never committed a mistake is yet to be born. So mind well, as judges also we may do some, say, we may decide wrongly. But ultimately, judicial decision is judicial decision. And when it is final court, you know, sometimes the cases are overruled also. Sankari Prasad, Sajjan Singh, Golaknath, Keshwanand Bharti, we are aware that at the interval of few years, the law was again declared and again it was said that this is not the position. So don't worry about it. But you must prepare yourself to the satisfaction of your conscience and put it. If you do it, in my opinion, you will be a successful lawyer and it will help you in future. Once again, I really thank Hiramsi and her team for doing this. Thank you very much.
We are enlightened by your speech, sir. Each word delivered by you are like golden pearls of your experience, which you distribute and which comes to us. Now, further, I would like to introduce Justice M.R. Shah. I am privileged to introduce Honorable Justice M.R. Shah, former Judge, Supreme Court of India and patron of Sambhav Initiative. Sir had served as a former Chief Justice of Patna High Court and former Judge of Gujarat High Court. He was enrolled as an advocate on 19th July 1982 and practiced in Gujarat High Court, Central Administrative Tribunal and various other forums. He was appointed as an additional judge of Gujarat High Court on 7th March 2004 and appointed as a permanent judge on 22nd June 2005. He was appointed as the Chief Justice of Patna High Court on 12th August 2018. Sir was appointed as the Judge of Supreme Court of India on 2nd November 2018. Sir retired from the Supreme Court of India on 15th May 2023. During his journey, he has delivered more than 700 judgments in the 4 years of career at Supreme Court of India, including many cases where he has demonstrated and has clarified the jurisprudence. We are extremely delighted to have Sir as a patron in our initiative, and his presence in this session is invaluable to us. I extend my deep-hearted gratitude and invite Sir to deliver for today's session.
Thank you. Respected Honorable Mr. Justice C.K. Thakkar, former Judge Supreme Court of India, as well my guru, because I was also a student and I attended the lectures of Justice Thakkar in the law college. My dear friend Tushar Mehta, who could not join because of his other commitment. Dr. Anju Rathiji, Additional Secretary, Ministry of Law and Justice. Ms. Hiransi Shah and her team. Pro Bono India. The respected members of the government, the governing board member, and distinguished and esteemed speakers who are to speak in the next 15 days. Once again, I am happy to be associated with today's inaugural ceremony of 15 days National Online Capacity Building Program on drafting and pleadings for the district court lawyers to Supreme Court lawyers. It's a second inning. First inning was played before 15 days. for the district court and trial court lawyers in vernacular language. After the great success, now Sambhav initiative and the pro bono would be having 15 days national online capacity building program. I congratulate Jiransi and her entire team.
Correct.
So far as the subject, drafting and pleadings are concerned, Justice Thakkar has already virtually covered everything. And basically, nothing is left for me. But I must say that we are lucky enough that we are having such a stalwart like Justice C.K. Thakkar, who himself is an authority on drafting and pleading and even constitutional matters. I studied and I learned so many things from Justice C.K. Thakkar. And even today also, I am learning from Justice C.K. Thakkar. Ms. Jiransi is very lucky that we are having such a stalwart and a great luminary as patron-in-chief of Sambhav initiative. As rightly said by Justice Thakkar, that for the purpose of pleadings, one must read thoroughly the relevant provisions of the CPC, more particularly Order 6 of the Code of Civil Procedure. It contains, Order 6 contains everything with regard to the pleadings, right from the plaint to the written statement. Drafting is an art. And right from drafting the notice and the pleading and the plaint in the suit till the drafting of the SLP, every stage is important and important so far as the litigation is concerned. Lawyers play a very important role in the justice delivery system. Everything, everybody, every litigant would depend upon the lawyer. Whenever, whatever the lawyer says, and he says sign the pleadings or sign the plaint or sign the writ petition or file the affidavit, correct? He will immediately, without even thinking what or reading what is there, correct? He will sign blindly, relying upon the advocate. Therefore, first thing, according to me, is, and I emphasize, that there shall not be any suppression of facts so far as the pleadings are concerned. You must write everything, every fact must be stated in the plaint as well as in the writ petition and or even before the Honorable Supreme Court in the SLP. A lawyer should not decide whether it is relevant or not. There should not be any subsequently defense that no, sir, according to me, that was not relevant and therefore I did not state in the written writ petition or the plaint. It should be left to the courts. But subsequently, as rightly stated by Justice Thakkar, that in a writ petition, which is a discretionary relief which can be granted in the writ petition, the court may refuse to consider the matter on merits and dismiss on the ground of suppression of material fact only. And sometimes a heavy cost for suppression is also imposed by the courts, and ultimately the burden of the cost will be upon the litigant only. Because the lawyer, as a lawyer, you are not going to pay the cost from your own pocket. Normally, you will ultimately the burden will be upon the client only. Therefore, one should avoid the suppression of material facts, and all the facts should be stated in the writ petition. Second thing, that in the writ petition or even in the plaint, all the reliefs which are necessary, which can be granted, must be specifically pleaded and asked for. Subsequently, you may be refused. You may be refused the relief on the ground of res judicata or constructive res judicata. You should ask everything. If it is not asked, correct, in that case, you may fail subsequently also. Subsequently, by amending the plaint also, the amendment application may be rejected also on the ground that the nature of suit is likely to be changed. So you should not wait till the amendment application is filed. Then the next stage will be the judgments. Apart from Justice Thakkar has already stated that everything, right from jurisdiction to the limitation, everything must be specifically pleaded, correct, in the plaint itself. One must ask those who are appearing in the district court, correct, must bear in mind that if the ground is strong, correct, the building will be strong. So you are at the ground level and your entire litigation, correct, the success of the litigation will depend upon what you are saying in the plaint and the right from very beginning. So far as the judgments are concerned, as rightly said by Justice Thakkar, in our days, we were not having the benefit of this computer and SEC online and all these programs and Manupatra. We used to read each and every book, correct, and we are going through the index, thereafter the next book, then the third book, whatever the judgments are relied upon, we were going to the earlier judgments also, and we were doing this labor, and we were happy also. But in these days, the only difficulty is that by one click, correct, you get the 10 judgments, and straightway you rely upon that and try to follow it. That's not the correct thing. Correct thing is that you should know the facts under which the particular judgment is given. Don't go by the index only, the head note only. Sometimes the head notes are also correct, misguiding also. So one should know, for the purpose of the judgment, relying upon judgments, suppose a particular judgment is against, prima facie against you, but at the same time, you should have an art of distinguishing that judgment, correct? And you can know that a judgment distinguishing features only by knowing the facts, that this particular judgment and the view is taken by the court in the peculiar facts and circumstances of the case. So please, according to me, no suppressor of facts at all, proper pleadings, proper drafting, right from notice to the SLP. We will be having 15 days, next 15 days training on online training on pleadings and drafting. The speakers are, I've gone through, speakers are very learned speakers in their respective fields, right from former judges and the lawyers also, on both the side, the criminal side as well as on civil side also. In criminal matter also, what is important is how to draft a complaint. What is stated at the first instance, correct, and which is treated as a complaint or an FIR will be relied upon and considered, and the trial and the fate of the trial will depend upon what is stated at the first instance. Similarly, in the civil matter also, the drafting of notice is very important, correct? All these things will be considered by and told and by the distinguished speakers who are public prosecutors also, additional public prosecutors, very senior advocates on the civil side also. Hiranshi is very lucky to have this number of, you see, the speakers, it's very difficult nowadays to get even good speakers, number of speakers, and we'll be having the benefit of all those distinguished speakers. I wish all the success, and I pray to the God all the success to the 15 days training, and I pray that the Sambhav initiative and Pro Bono will come with such new projects and programs which ultimately may help the common man and the litigant. Thank you very much for giving me this opportunity, and more particularly to listen Justice Thakkar. Thank you very much. Bharat Mata ki Jai. Jai Hind, Jai Jai Garvi Gujarat.
Thank you very much, sir, for this enlightening remarks and your insights on drafting and pleadings. Your remarks will surely help our participants in their process. And as we now approach to the end of this session, I would like to invite Dr. Kalpeshwar Gupta, sir, founder of Pro Bono India, to give vote of thanks and end the inauguration ceremony of 15 days online national capacity building program, legal drafting, pleading from District Court to Supreme Court of India. Over to you, sir.
Thank you very much, Rahul. Respected Justice C.K. Thakkar, sir, respected M.R. Shah, sir, respected Anju ma'am, respected Tushar sir in absentia, Hiranshi, all the team members and the participants. So first of all, I'd like to thank Thakkar sir, Shah sir, Anju ma'am, and then Tushar sir in absentia for joining today's inauguration session. So let me tell you, like we have received close to 900 registrations from all over the India. This is very, I think, big record, I would say, from our team, and the team did wonderful job. And obviously, because of the looking at the resource persons in the last 4-5 days, we are putting, I think we are getting many, we have got many calls from all over the India. Still, we are asking, okay, no problem, you can join, but we don't want to deprive them of this particular, this opportunity. So we have, sir, around 65% law students are there, and then 25% advocates and 10% others professionals and faculty members are there. So we started in last 4 months. This is the 4th event with Sambhav initiative and the Pro Bono India. So we started with mediation 1 week capacity building program on mediation. Then after that success, we did 10 days program on new criminal law. Third one, immediately Hiranshi sees after me, sir, plan something. So I had to think through what to do next. And then last time, we thought, let us do something in Gujarati. So we floated this the 1 week only. So 1 week capacity building program on legal drafting and pleading in Gujarati language. So it really immensely benefited advocates and law students from all over the Gujarat. And then in that, when we floated, so there were a lot of queries for there, sir, please plan something in English also, in Hindi also. And then Jayant was telling me yesterday, sir, for Maharashtra, sir, Marathi mein kuch kariye aisa. So I think we should have to do more program in different language also. But definitely we'll do something in upcoming months. So, and then like we can see, like rightly stated by Thakkar and M.R. Shah, sir, like I'm very junior to you, obviously, like I did law 18 years back. So drafting and pleading, so we had to write 30 drafts, so 3 marks for one drafting. So we have to, like, every Friday you have to write handwritten draft, and then 10 marks for the viva. So that was a paper in our time. I don't know how it's happening whenever I visit law school, sir. ऐसा कुछ नहीं हमारे हुआ. So there is nothing, writing in, handwritten things are there. It's Sauradarik Law College at Surat. So my friend is principal is there. So when I visited last year, so there was a journal. Then I asked Kalpesh bhai, we did this thing, in our college time. So this is a very good practice, And then in Pro Bono, sir, we also competition we have been organizing. So they are given the particular problem like PIL, consumer complaint drafting, and this. So handwritten, they have to read, because nowadays a lot of templates are available, sir. They do search and they just do here and there and they submit. Same thing happening in court, that is fine. But if you try this thing, and there's the last in Gujarati drafting also, we asked them to submit 2 drafts randomly. We picked up and they had to submit it, and they did very well. Especially some students, sir, हमने तो सीखा, we sir हमने आवड़तु नहीं, we don't know anything, we are in first year, second year. I asked them, no problem, whatever you know, you just do it handwritten and then submit. So that way, very good exercise. Same thing we have asked, will be obviously allocating particular topics for the submission as the completion of this particular program. So I hope participant will be get a lot of benefits, and obviously the great word from Shri Thakkar sir and MR Shah have rightly stated, sir. One last point, sir, like no, sir, Shah sir at least stated, like for the headlines, for example, live law, it's very spicy. The headline with this, and we start, okay, this is a very great judgment, we start reading, but we don't go like, like whatever you did at that particular time. And then in our college time also, we used to like, hardly I, sir, open AIR 3 or 4 times in my 3 year, I would say, let me confess right now here. So, and there was no computer was there, so nowadays it's very, very easy. So that's why we have to, like, a lot of things are that we have to refine those things, but before utilizing in our academics or before court of law, that way. So on behalf of the organizing committee, I'm grateful to Thakkar sir, MR Shah sahib, Tushar Mehta sir, Anju ma'am, and all the participants for the joining. And I hope we'll get the maximum benefit out of this course and try to enhance more and more throughout this particular this journey. So thank you very much. Over to you, Jane.
Thank you, sir. Thank you, sir. And with this, we just end today's inauguration ceremony. Are going to start with our first session, wherein we invited the assistant professor from Gujarat National Law University, who are going to take first introductory session on introduction to drafting and pleading. Thank you so much, Thakkar sir and MR Shah sir. Under your vision and guidance only, we are able to organize this event. Thank you, sir.
Thank you. Thank you.
Thank you,
sir.
sir.
Thank you, sir.
So participant will be starting our first session in a couple of minutes. Our research person has already joined, so we'll be starting in 2 minutes. Thank you.
Yeah, good evening, Kalpesh sir. I hope I'm audible.
Yes, yes, Adi sir, welcome. Yes, you are audible.
You are not visible, but
In the course बनाना पड़ता course.
Yes, yes. Hardik sir is the assistant professor of law in Gujarat National Law University, Gandhinagar.
He's been teaching for long, right? Advanced legal drafting also. Hardly taught at any law school. So I mean, also part of that, I have taken a couple of sessions in that. It's a great, I would say, innovative paper.
Kalpesh sir, I'm unable to start my video. In case you can make me
Yeah,
the
co-host.
co-host,
So हाँ,
Yes.
co-host.
I'll be able to do
technical
that.
team ka-
Yes, yes, yes. 1 second. तो co-host बना पड़ता मारवी.
Yeah.
Then co-host अपने को ना please make him co-host.
I think he is rejoining.
Okay. In case if there is a problem, can I share and we can start?
No, please make him co-host. You are not co-host, that's why you are not able to share. Yes, Jayant,
Right.
Marvi.
Yes, yes, sir. I'm looking it.
By the time, right, you can start introduction.
Yes,
Yes,
yes.
I will. Sure.
Now I
So-
would like to. Yeah. Yes, sir.
Yes, please go ahead. No problem.
Yes, yes. Now I would like to invite Ms. Rujal to introduce our today's speaker and guest, Dr. Hardik Parekh, sir.
We
Rujal,
have
over to you.
Yes, sir. We have amongst us Dr. Hardik Parekh. Hardik sir, who is currently serving as the Assistant Professor of Law at Gujarat National Law University, is also the Head of Training Division, Faculty Convener of the Legal Services Committee, Coordinator for Postgraduate Diploma in Intellectual Property Rights Program, and the Faculty Convener for Pro Bono Club Scheme under the aegis of Ministry of Law and Justice at the Gujarat National Law University. He has been awarded PhD in IPR law by the Gujarat University. He has been a visiting faculty for law in more than 14 different institutions in Ahmedabad. He was practicing advocate in City Civil and Sessions Court, District Court, and Gujarat High Court from 2006 to 2011. We are very honored to have you here, sir, today with us. Please, over to you, sir.
Yeah, thank you so much for kind introduction. Esteemed chief guest for today, the inauguration session, Honorable Mr. Justice C.K. Thakkar, sir, Honorable Mr. Justice M.R. Shah, sir, and Shri Tushar Mehta, sir, as well as Dr. Anju Rathi, madam, the team Pro Bono, team Sambhav, and all the esteemed participants who are from the different background. If I'm not wrong, they are comprised from students, faculty members, advocates, and also professionals. And I must congratulate all the team members to start this program on legal drafting. And I am invited as a first day speaker who will be introducing the entire subject in a crux as well as nutshell. And we'll try to discuss some of the interesting issues which I also encountered as being a practicing advocate few years back and before joining the formal academics. I'm sharing my screen, Kalpesh sir. I hope it is visible. Just let me know so that we can start. Yeah, if my screen is visible, Kalpesh sir.
Yes, yes, yes. You can go in slide some more and then
All right,
check
all right.
back,
I'll do
back
that.
and yeah.
Sure. All right. So the first session for the 15 days program on legal drafting and pleading, we are beginning with the introduction to legal drafting and pleading. Now here, when we talk about the introduction about the drafting, generally we understand what is drafting. Generally, we say the drafting is, we say it's an outline of documentation. Any kind of documentation we do. Here, we're putting on a word form, verbal form. So when we talk about the law, which is in a written sentence, written statement, we consider drafting as an outline. And we always consider that it's a preparatory writing of the documents, which are always based on the lot of negotiation, discussion, deliberation, brainstorming, and later on, it is put on a paper. So generally, we always use the drafting for different purposes. For the legal purpose is one of the important aspect. Otherwise, it is always for different kind of communications, different kind of the actions which are taken in different format, or in case of the academic also, drafting is available everywhere. It is very interesting to note that there is no specific book or codified statute for drafting. There are various statutes which we see in form of CPC, CRPC, as well as the new labor codes, where in annexure, some of the formats are mentioned. But then it is always based on the examples which has been given, templates has been given. And in a form of the legal drafting, there are very much important to know that there is no any specific law which is directly telling us that this is only the way you have to put it. And therefore, it has evolved in a long duration. It has been evolved in a long course of practice, long course of conduct. Generally, when we talk about the pleadings, there is always subject which is offered to law students in final year, whether it's a 3-year or 5-year law degree. There's a drafting, pleading, and conveyancing. Now, generally, we understand what is meaning of pleading and what is conveyancing. These are the two very broad areas of legal practice. When we talk about pleadings, it's inside the court. And when you talk about the conveyancing, it is always outside the court, where you enter into some of the drafts relating to the transfer of property, relating to some agreements which are done, or meeting of mind between two people. Now, both the things are very much significant for legal profession, because legal profession is all about the words which are there as a mutual interactions, mutual discussion, and putting somewhere on a paper so that it can be in future implemented. So that's a very basic aspect about the drafting. You can always keep in mind. So generally we say it's a crystallization and expression in a definite form of the legal right, privilege, functions, duty, or status, right? So when you talk about the drafting, what we do in case of the drafting, all the legal rights which we are pleading, you are putting it, all the privileges which are granted to us. It may be relating to certain functions, or it may be duty, or any status of the party. Everything is put on a paper with regard to the legal drafting. Now, as one question, fundamental question is always asked, okay, what is drafting and connection with the legal firm? Now, here we can always keep in mind that we always say that when you talk about the democratic system, there is always foundational stone in form of the written law. I'm sure law students and practitioners here would understand that when you start learning constitution, then we are always understanding about the nature of the Indian constitution. And in that nature of Indian constitution, we talk about the federal structure as well as the, the unitary form of the constitution. And when we talk about the federal structure of the constitution, we always say that there is a written law and written constitution as a first significant requirement, right? Similarly, when we talk about the democratic system of the government at all, which is different than the other systems where the monarch system is available, where most of the time the laws may not be necessarily in writing, but it may come as a royal prerogative, royal order. Now, what is meaning of democracy? There is a written laws. Rights have been very categorically mentioned on a paper and it has been given to you. Now, there is a big issue with this particular system. Now, what's the big issue? That when you talk about the right, it may be a fundamental right, it may be a constitutional right, it may be a legal right, or any kind of the other statutory rights. There is always a scope of interpretation. There is always a scope of understanding that in what manner, in a what word, you take this particular right in a what particular language. And therefore, the role of drafting comes into picture here, that how you are effectively putting the words for the benefit of the people, which has no scope of any interpretation, which may be different than the intention of the writer. At the same time, it is also satisfying the requirement of the democratic system that people should be given the right, and the right, in case it is violated, can be appreciated or can be enforced by the court of law. And therefore, we always believe that written laws are everywhere important for the democracy. Also, you can keep in mind that the democratic system and legal right would not effectively work if there is no vigilant citizen as well as the responsible lawmaker. There's a combination. You can apply the mind and you can always note down this. Vigilant citizen, responsible lawmaker, both are very important. Now, why I use the word vigilant citizen? You take example, there are plethora of laws, there are multiple rights, but then citizens are not aware that what rights are available to them and how to get it enforced. Again, the democratic system would have certain kind of inherent problems. It won't be sustaining very properly. At the same time, when lawmakers, the people who are in the place of making law, who are expert as a politicians, who are sitting into the legislature and making the law, who are executives, have certain kind of the rule making power. If they are not responsible, then also democratic system won't come. And in both ways, the drafting is playing very important role. And last but not least, we always say that legal awareness is a very important aspect. Whenever it's a different issues are connected with the society, legal awareness comes. So now you can always keep into mind that whenever the laws are enacted by the parliament and which is subject to enforcement, there is always a question of legal awareness. It may be relating to any subject. It may be relating to personal law. It may be relating to constitutional law. It is relating to giving some benefit to the people and whatnot. And therefore, this all interesting portions of the subject is making the drafting portion very, very important and very, very imperative. I hope I am reaching out to you and we are able to discuss. Now, when you talk about the legal drafting, what are the different parts and different scope? Primarily, we divide the drafting into three broad categories. First, you can say it's a functional drafting. Second category, you say it's a persuasive drafting. And third category, we identified as an informative drafting. Let me tell you, there is a scope of legal practice in all the three areas. There are many examples which I will give you, and you can always try to understand. And it is also very important that law students who are planning to make their career, who are planning to select their career, can always choose as per their internship experience, as per the legal understanding, whenever the discussion is happening in classroom, that is which portion they want to go. Now, what I mean by functional drafting, I always say it's all about the future. Okay, if you study about the consideration in a contract law, it is always taught to you in a classroom that consideration may be past, present, or future. Now, what does it meaning of the past consideration, present consideration, future consideration? Something done in a past, you are doing contract for that. Something going to be done in future, you are doing contract. And something which is right now happening in present and you are doing contract. Similarly, the drafting also comes. I always say that functional drafting are the drafting which is made on a paper first, and in future you are going to execute certain tasks. Now that is mostly important part of the conveyancing. So you do sale deed, you do mortgage deed, you enter into the gift, you enter into will, or all kind of agreement. There is a very great regime of the agreement drafting, contract drafting in our country right now, with the expansion, with the development of the modern legal system. A lot of advocates, a lot of lawyers are always doing practice and trying to understand the knowledge with regard to the contract drafting. So this is functional drafting. You put on paper. Let me give a simple example. I want to enter into contract with you. I am going to be your consultant, and you are here in front of me. You are appointing me as a consultant. First, we'll jot down on a paper that what are the intention of the parties first. What I am supposed to do, what you are supposed to do, what amount I am going to get in future, and what will be my responsibilities and role. Once we are ready, we are agree, whatever oral discussion we have done, we'll put on a paper. And when it is signed, executed, later on, for the next years, maybe 1, 2, or 5, I will work as a consultant for you, and then payment will be available to me. So that's the kind of functional drafting. To carry out particular function, you do that. So entire conveyancing will come into picture, whether you talk about MOUs, whether you talk about consultancy agreement, whether you talk about the employment agreement, when you talk about the different kind of the advanced contract include joint venture agreement, franchise agreement, the agreement for financial collaboration, and many more. This all will come into future. So first category, I'm sure that now you understand that there are experts who are practicing in the era, because the legal drafting, I would like to give a sentence statement to you, and you can always coordinate or you can always develop it further, that it is a galaxy into the field of the legal regime. Law practice may be considered as a universe, and a particular drafting portion comes as one of the galaxy. Now, what I mean by that in law, there are multiple facets, there are multiple angles of law, right? Because law having great importance in democracy. And when you talk about the law, there are law making procedure, there are law enforcement procedure, there is a law requirement. There is a great area available where a lot of experts go to the field and find out whether enacted law is effective. Number 2, if not, then what are the legal requirements in future? And accordingly, submissions, the report and submission of the report to the different lawmaking bodies and making the law. So law has a multiple dimension, multiple facets. It's available with us from cradle to crematorium. So more and more you study about the law, more and more things would come out in you. That's not a subject of the discussion today. But drafting is one of the galaxy of that. And therefore I say, why I call galaxy? Because in galaxy also, there are multiple stars, multiple planets, and therefore functional drafting is a one segment of that. The persuasive drafting is a second separate segment for that. And third segment will come in form of the informative drafting. So that's the important portion, and the law students can always do. And accordingly, you can do internship. There are lawyers or who are doing documentation tasks. They are always doing the type of the functional drafting. Second drafting, which is a point of the discussion for entire course, is persuasive drafting. Now, what is meaning of persuasive drafting? You are always going to pursue the court, and persuasive drafting is all about the past. I hope you understand, and you can always make a note of that. Functional drafting about future. You are going to do something in future, you are putting on a paper right now. But persuasive drafting, something has already done in the past, and then you are putting in front of the court. So this is all about the single party, or it's a one-sided. Like whatever arguments you are putting, the plaint, written statement, or affidavits, or a criminal complaint, or public interest litigation, or a writ petition, or any form of the point which you put in front of the court, and you want court to understand your contention and court to give you the right granted to you. That is coming under persuasive drafting. So what happens in persuasive drafting? Like today I am filing a suit in front of the civil court. Now why I will come to the level of the drafting of suit? Because some rights have been violated, which might be done last year or the last year, for which I might have drafted certain legal notices. I would have tried to settle the matter voluntarily at my level. But when there is no decision, where there is no disposal of the matter, I am coming in front of the court and this is the last resort as per the rights granted to me by the laws of the land. And please help me. So it's all about persuasion. Now see, in persuasive drafting, when you talk about pleadings, which you are going to learn in the next coming days from the different learned experts, is all about that you are always appearing in front of the court on behalf of one party. It may be either plaintiff, it may be defendant. Either it may be the appellant, it may be respondent, it may be complainant, or the opponent, and whatsoever. Now here you are only talking about the one-sided aspects, that my client is correct or my client is right, because these are the evidences, these are the proofs, and these are the subject matter on which I am relying. So that's a persuasive drafting. The intention is to pursue the officer in front of you. It may be a judicial officer, it may be quasi-judicial authority, or it may be a simple authority which is given a right to adjudicate on certain kind of matter as per the delegated legislation. So that's a persuasive drafting. So I hope you are getting the difference, that functional drafting about the future, persuasive drafting about the past, and then putting in front of the court. And third is informative drafting. What we mean by informative drafting, that it is generally about the information. You take example of the newspaper advertisement every day. Now, when you see newspaper, the legal information, public notices, the information which is available in front of people from the banks, legal opinions, letter of credits, these all things are coming as an informative drafting, which is done on behalf of the client in order to come out with certain kind of aspects. So these three are the broad bifurcation and division about the drafting, and you can always have a look to that. Kalpesh sir, if you are there, you can stop annotation on the screen, please. There are certain
Yes, participant.
available.
Sorry for interrupting.
You can simply enable annotation. There is an option available in Zoom.
Yeah,
so
I have already
annotation
disabled like messages.
will happen.
Okay, I think that
Yes, it will be disabled, or it will.
I think everything is disabled. We have done like chat also, because video and docs also.
No, here there are certain annotations which are on the screen, and going on a high level, people will be able to see that. All right, fine.
Okay, sure.
Now, before we go for the other important aspect of the legal drafting, let me share one interesting story. This is a real story. It's a real example, and you need to help me that what will be the reason, what will be the final outcome of this. The story and the example which I am going to share is about the Hindu Marriage Act, Section 13B. Section 13B is a very popular section. I hope you are aware that whenever the husband and wife are willing to get a divorce by mutual consent, they can always go in front of the court, and family, they can get it disposal. Now listen this very carefully, and this is the small example which is personally observed by me, and then it is helping you, or it is going to help you to understand that what is the significance of the proper drafting, and if it is not done in a proper way, what happened. Now, the matter, I will have to hide out the names of the party. It's a really actually happened issue from the year 2012. In 2012, two parties, two husband and wife, both were residing into Ahmedabad. Okay, so they they decided that now, because the marriage life is miserably failed, we'll go in court and we'll file out the divorce petition. So under 13B, they went to the court, and then they find out the divorce petition. So 13B, husband and wife went and filed the matter. Now they hire an advocate, and generally you must be knowing that in certain cases, this kind of cases, one advocate is sufficient enough. They will go and they will file a case that both the parties have decided to get mutual separation, and there is nothing to be discussed now, and court can go forward for grant of the decree of the divorce. So that was a simple matter, as simple as this. Now in this matter, what happened? That wife was localite from Gujarat, and husband already was qualified to get a job in outside India, and he was planning, once divorce will be done, I will fly back and to my different destinations, and I will start my job, and I will start my activities in future. So both applied. In 2012, they appeared to the court. It was almost in June 2012. They appeared to the court of law, family court in Ahmedabad, and they filed the petition. Whenever this kind of applications are filed, court is always first sending to the conciliation. And when you say that conciliation has been failed, the conciliatory report is coming, court will say, okay, we are accepting your petition. And then second time, the husband and wife have to come to the court for deposition. So they have to come out for the deposition. Once deposition is done, then court go with the formal. This is a very standard procedure which is applicable according to the law. Now what happened that in June, both the parties appear, the matter was filed, and advocate which was appearing on behalf of both the party came back. Now after 6 to 8 months in 2013, the husband already went to the South Africa. Johannesburg was a place where he started his particular employment. And then the lawyer of the wife and husband started up asking them, okay, now it's a time you have to come back to India. You have to come to Ahmedabad. Your deposition is required. Your affidavit is required. So please come and depose in front of the court. Now he was not able to come. There was some multiple kind of discussion, call, as well as the email. but then he was not coming. Now wife was very young, and there was a pressure from the family members of the wife, and therefore wife was willing that the matter should be expedited and I should get divorced very soon. And therefore the advocate was told that you go and all right. So wife told us advocate that, sir, it is getting very delayed and my life is at stake. Please do something. Now here there is an interesting point coming, that advocate drafted a petition. This petition was actually put in front of the court. The petition was something like that, that your lordship, the husband and wife has asked for mutual divorce by mutual consent under this section of this law. And this matter has been filed in court of law for more than 8 months. Now husband has moved to Johannesburg and there is a stage of deposition. Husband is not coming, and therefore I request you to please pass an order that the summons can be served by email to husband so that he can come to Ahmedabad and he can depose. Okay, this was the petition drafted by the advocate on behalf of the wife. Okay, now listen very carefully. Okay, the petition was like this, and then it was submitted to the court of law. Now, this petition was filed, and when it came on the desk, the advocate was called by the judge and asked, okay, Mr. Counsel, do you really want us to decide on this petition or what? Advocate say, yes, you can, sir, go ahead and pass an order. Now, here I would like to ask you, in case you are able to write in a chat box, that what judgment judge would have passed on this particular application. This is the application which is done in between the petition which is already pending in the court of law. It is about the mutual consent divorce. This petition is for the mutual consent divorce. Advocate has written, I am willing to call husband here. He is not coming, and therefore I request court to please pass an order on this particular application, that court will officially send email to that particular advocate or to the husband who can summons, and he can come to the court. Anyone can write it in chat box. What would be the reaction of the court? What judgment court would have passed? Yeah, anyone can write in chat box in case you are able to write. What would be the response of the court here? Yeah. X party, very good, very good. So nice. X party. X party, great, great, great. X party, X party. Someone has written court will dismiss the petition. Court might have disallowed. Okay, okay. Now listen what actually happened. Court filed the order on this petition that the application or the mutual consent divorce petition is hereby dismissed, and the parties are entitled to appear before the same court on the ground of section 13 of the Hindu Marriage Act, which is the divorce petition by the separate husband or wife. Now see what happened here, that the intention of the words which are written on the application was read by the court is that when the petition for mutual consent was filed, it's a condition prerequisite that husband and wife both are agree to get a divorce. Now the wording which is written on the paper is showing that now after husband has gone back to the South Africa, he is not willing to get a divorce by mutual consent, and therefore court is disallowing the entire petition, and now we are cancelling or we are dismissing the entire petition under section 13B, because now the situation has changed. There is no intention and there is a deposition pending. Now see, this is the example that in case the petition is filed or any drafting which is done not in a proper sentence or not in a proper way, which is actually expected by you, this kind of disaster may come out. And therefore, entire court was shocked here, and actually the petition was dismissed. Later on, husband was not really returning. Wife had to go to the court again under the fresh petition. This petition came to the hearing in 2013 after a waiting period of almost 8 months. And during 8 months, I don't need to tell you that the fees of advocate would have been charged, the transportation amount or transportation charges would have been there. There would be a huge amount of expenditure which have been done. So one small mistake, if you are not able to draft in a proper way, and then entire matter can go out. This is only one example which is personally observed by me. But there are a plethora of examples like that. and courts and judges would definitely read it in between the line. And therefore, the drafting and pleading is so significant in court of law. We are not touching the convincing part at all. Otherwise, there are so many examples of convincing also, where just because you are not able to mention properly about your rights on a paper, what you are willing to do, there can be disaster. And therefore, there is a requirement, and therefore, it is very well mentioned that any person who is seeking the assistance of court of law in matter has to prepare a statement of the claim. And that statement of the claim we call as a pleading. Because on what basis you are telling that these are the statements which are fully drawn up, which are setting by all contention, whatever you are planning to put in front of the court is called pleading. Like example of pleading I gave, 13B petition, divorce by mutual consent. So you are taking a particular format and you are writing in every categorical wise that in which year the marriage got solemnized, what was the place of marriage, then what actually happened so that the husband and wife decided to get separate, everything. So whatever is your claim, finally your claim is that because of the situation which has been prescribed and described more particularly in the pleading, the husband and wife is coming to conclusion that they are unable to stay together and therefore they are willing to get a divorce by mutual consent. So that's what it is calling, it is included as a pleading. So pleadings we call as a foundation of all sort of litigation. Whatever litigation you say, it's a foundation. And I hope you understand that in litigation, litigating lawyer, or in maybe you are litigating lawyer in the field, or you are a research intern, you are assistant to the lawyer, or you are judge. No, petition which are pleading is important because not a single judicial system of the world can do justice if there is no pleading. Okay, because justice delivery system wants that all the facts, claims, contention of the parties, including counterclaim, including defense, including the evidences which you're relying, are put in front of them in a very clear-cut sentence. I'm sure you would be watching a lot of movies and documentaries. Today, so we can say it's a golden era for the law students, because in case you need to understand some of the legal issues, there are plethora of the web series, there are wonderful quality web series which are available, which always talks about the legal points, right? There are multiple issues relating to law which may be so difficult, which may be so complex to understand. But there are certain legal experts who advise them. And then nowadays the producers are making certain very interesting web series. In that you might have seen this argument, and whenever the cross-examination is happening in a court of law, you might have listened this point very carefully. That, my lordship, the opponent or the respondent or the plaintiff is relying upon this sentence, but this is never claimed. So whenever you are putting pleading, it's always important that what actually you are claiming and what is the base of this claiming. And therefore pleading is a significant portion in the legal drafting. And all advocates, all law practitioners, the good, more clarity and more best experience they have in pleading, then more appropriately they are able to get the justice from the court of law. Now, what are the histories of the pleading? That's also very interesting to know, because we talk about the democratic system, the pleading, and when you are talking about drafting has a lot of connection with the democratic system of the society also, right? Because when there are written laws, there are rights which are in writing given. It's a guarantee by the government to the people. And whenever the situation arises, these rights are coming at a stake, and there is always requirement to go to court. And here you remember again the Lord Atkins' very popular sentence, power tends to corrupt. Absolute power corrupts absolutely, right? You might have heard it 1,000 times. You might have experienced that also. You can see around and you can find out that what is meaning of this now. Now, whatever century it may be, the sentence becomes so appropriate in every time. Whenever people have certain kind of the powers with them. I repeat, power tends to corrupt. Absolute power corrupts absolutely. So generally, what is meaning of power? Power means any kind of power which is given to any officer. He may be a government officer, it may be a parliamentarian, or it may be any kind of the judicial officer. Whatever powerful people we have by virtue of the constitution or by virtue of any law. And then it is a tendency that in case the power is not implemented properly, what will happen? There will be abuse. And abuse of the power has clear connection with the violation of the right. Now, you make me any powerful officer. You suppose you gave a power to me that I am going to be a chief minister, I am going to be a prime minister. And then if I come out with the law, and because of this law, which might have certain flaws, which might be taking right of the people, directly, the highest law of the country has also given me the right that you go and get it enforced by the court of law. This is the present system, which is after the 19th century we are observing. But in ancient time, we always start that king is called the fountain of the justice. So king's bench or king's court is always identified for rendering justice, and therefore whoever want to get justice, they will appear before the king, and all the thing will happen in oral. So king will listen to the plea of one party who may be a petitioner, and then the king will call the opponent, and the opponent will be summoned. And then in front of them, the cross-examination will happen. Here, sometime the amicus curiae, right? The expert will also come into picture. And then for this, you can understand that Akbar Birbal stories are very interesting and very popular. So whenever Akbar and Birbal stories are there, you find out that the Birbal is coming into rescue when the legal point is coming or when some kind of complexity is available. And based on that, the judgment will be passed by the king. So this is the generally the procedure which was available. There was hardly any system of written statement. Okay, this is the era of the oral pleading. So in history of the law, it has been mentioned that oral pleadings was once upon a time, because generally it all depend upon the king. When there's a democratic system not developed, king will say, and whatever king is giving, that become the justice for the people. But slowly, gradually, with the passage of the time, this system got changed, because when you study the Contempt of Court Act, the same is applicable. So why Contempt of Court Act? I am sure many of you would have studied the Contempt of Court Act. The history of the Contempt of Court Act is also giving this idea that once upon a time, the king when giving justice, slowly, gradually, when kings are too busy with the administrative matters or with the war, then in absence of the king, the chancellors and the legal experts are appointed, and the declaration is made into the city or into the town that we are appointing, nominating these people who will render justice to you, and whatever respect you were giving to me, the same respect you should give to these chancellors only. And therefore, slowly, gradually, this became the system of the court. And later on, today also, you cannot do any kind of activity which can defame or which can diminish or which can damage the dignity of the court. Similarly, the king and court are there. So in contempt of court, the same things have been explained. So this system came, separation of the justice happened from the king, and therefore there was a lot of complexities, because you can imagine that there is no system of maintaining record, and oral pleadings are happening. Next time, after 2-3 days, next adjournment, when it is not written anywhere, scribes are not there, there will be multiple things. You have to recollect again and again. And there are always chances that justice may not be served. And therefore, this method got replaced. Litigants were allowed that, okay, in case you are litigant, bring your written statements and claim, which you will submit in a court of law, and court will do this. Court will take the help of this. And therefore, this system became easy for recording. And history says this became the system for pleadings. So this changes help the court for smooth functioning also, because court are able to generate the record. And this method of oral pleading can help when few matters are there. But when the country is very wide, when there are hundreds of litigants, every litigant had to come to the court of law for justice, it's next to impossible. And therefore, in order to expedite justice delivery system, pleadings are considered to be the backbone. And in 19th century onwards, the history says that proper procedure came for a pleading. And therefore, different legislation also drafted that now, in case you are coming with the civil suit, this is the format you have to follow. The permission which is granted by the court, this is how the issues will be framed. This is how the court procedure will happen. So this is the history of the pleading which is available. So now you can understand what will be the object of the pleading. Object of the pleading are very important, because there is always an intention that you should always have to understand the case of the opposite party. I'm sure you understand that. Suppose like students who are preparing for moot court competition. Now in moot court competition, when moot problem is given to you, it's always giving you interpretation scope for both party, that what is contention of one party and what is contention of the other party. And therefore the pleadings are there. So you are always doing that, why I am going to represent myself, how I am going to represent myself, what I am actually going to research, and what I am actually going to do. There can be a simple matter, single matter, but can be multiple dimensions of that. Take simple example of the tort law cases. When you talk about the tort law cases, when the law in a proper way, civil system or criminal system, which is not codifying any subject as a criminal wrong, then the concept of the tort has been there in existence. So you study all the cases relating to tort, it is giving you the same idea. Is it a case of nuisance? It is a case of negligence? Is it a case of wrong against property? Is it a crime? What is the gravity? And therefore, why you are going to do the contention, that's very important. And second and most important thing which I collect with the pleading is principles of natural justice. I hope you all have studied the principles of natural justice, that you are not going to take a call unless and until opposite party is heard. Opposite party is heard. And therefore, you are always going to understand that what is the main subject and what is the stand of opposite party and what are the admitted fact by them, what are the denied fact by them. And therefore, these pleadings are ultimately helping in a fair trial. So what is fair trial? You are always knowing that court will always take care about the proper thing and they will give equal opportunity to both the party. And therefore, this is going to be the important aspect of the pleading. So I hope that now it is very clear about the basic aspect, drafting, why you need to understand the pleading and what are the important part of the drafting together. Now, when you talk about the drafting, it is very important that generally how we draft. The expert will come. Let me tell you, it is all about learning by doing. There are no separate classes for the drafting where you listen something and you become expert in drafting. That's next to impossible because good draft come from the practice. And therefore, these 3 points are most significant. I'm sure all the law students can always keep in mind that good drafting is coming from the practice only. Generally, what we do, we go to library and library has so many books in which templates are there, drafts are mentioned. But let me tell you, taking draft without applying mind can create a disaster because you never know with what intention that draft has been created and how it is important for you. So you can always take the important paragraph that how the paragraph number 1, 2, 3, 4, 5 is required to be arranged. But rest of the time, you can always do this. So I have mentioned it that books and templates of the drafting are providing structure, but structure is not drafting. Okay, it is only structure because suppose you are drafting plaint, you are drafting written statement or you are drafting simple notice. There's a structure that first you write the name of the party, then you write the what relationship is established between you and that party, then write down that what is legal relationship, then write down what wrong has been committed, then write down what happened because of that you are claiming or what is the ground of this, and finally what you are paying. So that's a structure. Structure is not drafting. So I have given an example that good clothes are not making handsome and successful man. It is only adding to them. Okay. So if you identify someone as a handsome man and successful man, you don't say just because of the good dressing they are successful. It's all about the contents. It's all about the inside available. And therefore, the good drafting is like an internal component. And structure and templates are like an attractive packing. If your draft is very well structured, it will be appreciated. It will be taken into hand by honorable judges. And whenever they will observe it, they will find out that yes, proper structure you have mentioned. But later on, another person will come into example with the internal concept. And therefore, there is constant requirement of practice. More and more drafts you read, more and more draft you put on a paper, and then it is coming. So this is what the important aspect for the legal practice you can say. Now, before I was preparing for drafting, there was a small survey done by me. This survey was about just asking the students that how much effort you are putting relating to the understanding theoretical aspect of law and how much effort you are putting to understand the drafting of law. And you can see the result. 80% is an effort which we are putting to understand the theoretical aspect of law. And hardly 20% is coming when we are putting that into drafting. Now, what is the example of that? I'm sure all of us are very clear about consumer law. Okay. So what is meaning of consumer? What are the rights of the consumer? And what is meaning of consumer court? We all know, right? But suppose today you go to court or suppose you go to market and there is a defect in service, defect in a goods, or there's a deficiency in service. I'm sure many of us won't be able to understand that how to write a complaint and where to write a complaint. Because in a theoretical subject, drafting is hardly touched. You are knowing that generally we teach drafting as a final year paper. But generally nowadays time has changed. In our university, what we do is that drafting is always connected with some of the aspects. So whether you learn company law, you learn tort law, you learn contract, little bit kind of drafting is always going to be explained to you so that you can get exposure. And this is unfortunately the reason that why there are so much litigation in our country. Right? I gave example of the consumer law. You take an example of the contract law, which is generally taught to the students in first year or second year. Now, we all know about the contract, but generally we never draft the contract, or when we are signing the contract, we don't understand what is boilerplate clause, what is recital, what is the name of the party, what is the exit clause, what is the sunset clause. These all terms are completely new for us. And therefore, we are unable to get the justice quickly from the court of law. Forget about this all things about contract or consumer. There's a simple application which is required to be made when you want duplicate share certificate, duplicate document from the government. For that also, simple templates are required, but that kind of legal drafting is also not very common and popular. It's only with those people who are able to do that. And therefore, there's a great requirement to understand the topic in a detail, because most and most important significant legal practicing is coming into this form. So this was a survey which was done and result is in front of you. So as we say, legal drafting is the heart of legal problems. Legal drafting is heart of legal profession. Why I call legal profession heart? Because I told that unless and until you put everything on a paper, the opposite party can never read what is there in your mind. And therefore, lack of proper knowledge of the subject will result into multiple things. In case you don't learn the subject drafting, in case you want to practice in law, but then there is a weak point that you are unable to draft, what happens? Number one is increase of litigation. Do you think increase of litigation is greatly connected with legal drafting? Yes, absolutely. Why? I give example. That one matter of 13B has been made out. And this matter, as it is wrongly, one application wrongly drafted, technically, there would be other ways which can be there, that how you are able to approach to the court and how you are getting adjournment. And court will ask that why you are getting adjournment. And then say, sir, we need to call the person. And for that, summons is required to be served. It would be great if you can give the next date and summons can be served. So if the drafting is not proper, multiple litigations are coming. Let me give a small example. You all have heard that when you are drafting a civil suit, you are drafting, submitting the civil suit, but you forgot to mention some of the important aspects. And that important aspects are not included in the suit. Now, those contention you will not be able to take when you are arguing the matter. Civil, as per the CPC, you know, that suppose there is a suit. I am a owner of the property and my neighbor is a tenant. Now, there is a dispute between both of us. Now, in that dispute, I have to raise the dispute categorically. Number one, he is damaging my property. Number two, he has not paid rent from so many days. Number three, he is doing the activity which is violating the society norms in which I am staying. This all contention I need to take, and therefore at the end I am seeking that based on this, I want a blank and vacant possession of the property. Now suppose I forgot to mention about this nuisance which is created in society, and I forgot to mention, or there is completely omission. Now what happens here, that suppose if something has not been written in a suit, I have to amend the suit. So for that separate application I need to find that, sir, can I amend the suit? Now that application will again go to the defendant lawyer. Now defendant lawyer will see this. He will also be able to argue. He will also able to oppose. And when this opposition and application of this suit has been successful, then court will say, okay, you can always amend the suit. Now when I amend the suit and suppose the opponent is again rejecting, one more petition will be there. You must be knowing, you all know what is exhibit, right? Exhibit in a mark, there are two interesting points. So whenever we submit the list of documents to court of law, there are always mark. Suppose list is exhibit 3, documents, 10 documents with the list. So you say mark 3/1, mark 3/2, mark 3/3. Now, there is a rule that when Evidence Act will give you idea that how any document can become an exhibit. So you are putting it either in form of the original document, or if it's a photocopy of the document, you are proving it in respect of the deposition. So suppose I don't have original rent agreement, but I have the Xerox copy of the rent agreement. I put it. And then if any witness is coming, and in deposition, if courts think that yes, it is successfully proved, then court will give exhibit to that. There are litigation where exhibit is given by the court, and opponent lawyer will say, no, I object. So I want to file an appeal to the higher court that how come court has given this document as exhibit. And there are litigation just in order to have an exhibition on the documents also. So this is the legal field which can say. So this is the example which is there. So there are multiple orders. If the drafting is improper, there is no proper connection with the law facts and different kind of the reality. There are multiple litigation, and therefore it is increasing into litigation. And because of that, there's a delay in justice. We always told, I am sure all of you have seen the National Judicial Data Grid. I am sure you might have visited this website, National Judicial Data Grid. You can always visit the National Judicial Data Grid. I think Dr. Kalpesh Kumar Gupta can also put it, National Judicial Data Grid. Now, this is an interesting website where you see that Supreme Court of India have come out with the multiple dashboard in which court how many matters are pending. And when we take this example, we always come out that this many matters are pending in lower court. And what is a delay in justice? That's a fault about drafting. That court is unable to understand what is written, and they want to appreciate the principle of natural justice, and therefore they want to give opportunity to the client once again. And because of the faulty drafting, maybe in a plaint, maybe in written statement, the real intention is not coming, as there is a multiple repercussions, and therefore delay in justice happening. And finally, there's a disruption of the legal profession also. I'm sure all the people who are connected with the legal profession will always agree that clients are always blaming that advocates, judges are making delay, we are not getting justice. But ultimately, there is also connection with the drafting also. So there are multiple facets which are available. So this all the things we have to keep in mind about that. So now what happens when the drafting is poor? There are multiple implications. One thing is double and doubtful meaning of intention given shape of the document. You have published I give example that there's a doubtful meaning, double meaning. Now I intend to say, okay, sir, that person is not coming because he is not accepting my call. I want court to help me by sending a summons by email. So this was the intention. But how court read it? Okay, no. When you have written, that means the person is not interested. So implication of the poor drafting is this, that there is a double meaning, doubtful meaning, and therefore the shape of the intention will not be clearly available. There will be ambiguity and difficulty to interpretation of the documents. Now, what I mean by ambiguity and difficulty, you can understand. Take one more example. There's a contract. Now, the contract has been drafted between A and B. Two parties, A and B, are entering into contract. Now, in this contract, they are writing that we are entering into contract today on, say, for example, 20 August 2024. And the contract will come in existence and contract will remain in existence till the time we are satisfactorily performing our obligation. Now, this is an example of the small contract. Now, what does it mean? Whether is it a perpetual contract or you are intending to cancel the contract only when there is a fault. That means whatever you have written, that A and B is entering into contract today and contract will remain in existence till the time parties are properly performing that obligation. That means till the time you are performing, there is no violation of the contract. So there is a one-sided contract, means even another party is willing to get exit. They cannot do that. So that's an ambiguous clause. And therefore, you are always learning about what is good contract. Similarly, when you are drafting a plaint, when you are drafting a legal notice, if you are not clear with the law, if you are not clear with the facts, this kind of doubtful double meaning will come. And ultimately, the matter gets stagnant. So this is the, again, second thing which is coming. Third is difficulty in implementation of the objective desired in the document. If there is a drafting which is poorly made, you move the application to a court of law, and that application has inherent difficulty, and therefore it is not possible to be implemented. Generally, when we are talking about the drafting, we get a lot of input from the judges. Now, when Honorable Justice Sir came here, and I'm sure he also have certain kind of observation. Of all the judicial or members have one of the observation that when we get a wonderfully properly drafted application, we become very happy. And we are very happy that it is in simple language and we can categorically get what the parties are required, and it is very easy for them to dispose the application. But when the application is drafted and there is no clarity, what is written here, what you are intending, how it can be implemented. And therefore, I'm sure you are knowing that in suit, in a writ petition, you are always writing the last prayer in writ petition. Any other relief which the honorable court may find proper and just may be granted. Now, why you draft it? Because there are examples that you have asked. Number one, I want this much money as a compensation. Number two, I want status quo, I want injunction application, and there is no third relief. Now, when court come to conclusion that based on the evidences produced, neither you are entitled for compensation, neither you are entitled for the status quo, then how court can grant a relief to you? And this has happened in the past, and therefore the advocates are writing that any other relief with this court is naming proper can be granted. So that's a clause which is giving right to the court. Okay, if we are not able to give this, but we are satisfied that some ground have been made by the parties, we want to help them. And therefore, they will help them with the help of the thing. So these are the things, difficulties are available because of the poor drafting there. Number three is increased litigation. As I told, that many litigation against government. You must be knowing who is the biggest litigant in our country, the government. Okay, you check the example. private litigations are there, but maximum litigation you will find out either it is initiated by the government or it is against government. Government is a big department. There are multiple ministries, multiple departments. When you take corporation, different wings of the corporation. Now, why this wings of corporation? Because generally it is observed when we do training of the government officers and then this matter comes to us and we get to know that if one public notice is not properly drafted, take the example of single tender application. You might have heard that recently a railway ministry cancelled the tender for Vande Bharat train, right? Now, there is a law of tenders also. It is relating to drafting. Now, there is a faulty clause, one small clause which is faulty drafted in a tender. And because of that, if the petitioner or the people who are willing to fill the tender are not able to do that, immediately matter will go to High Court by virtue of the writ petition. Sir, Honorable Court should grant an order that this tender process should be stopped because there are inherent problems. Now, this problem may be relating to money, may be relating to performance, or may be relating to any other thing. So, if there is a poor drafting, even simple tender notice or legal notice or a suit or written statement or any other thing is multiple creating the implementation. And therefore, there is a loss of money, there is a lot of human resource, and many more things comes. So, these things are coming. Finally, there is a misinterpretation of the facts leading to wrongful judgment. When you are unable to draft your proper litigation or pleading properly, there is always misinterpretation of the facts, right? The facts are misinterpreted. It cannot be understood in correct sense. And then the wrongful judgment will come. Ultimately, matter will go to the court. And then the harm will cause to the innocent persons. We will not blame the advocates always. But generally, when there is a proper briefing not done by the person, and then the things are put on a paper in a different manner, and there will be a loss. So this all are implication of the poorly drafted petitions. So in case it is not properly done, it can happen. And therefore we say drafting is a composite art. I say it's a noble work. Why it is noble work? Because we always say there are three basic essentials requirement for the human life: food, shelter, and clothing. After these three satisfied, what fourth comes? It's a justice, right? So three things: when you get food, shelter, clothing in life, the fourth requirement of human being is justice. And for justice, you go to court, and advocates or officer of the court will help you. And therefore, the drafting is not only a simple profession, but it's a noble profession which is helping people to get justice from the court. And therefore, all the people who are involved with the drafting have to think, I am earning a lot of blessings, I am earning a lot of wishes from the people, because if because of my drafting, if someone is getting justice, it's an extremely high thing for them. And therefore, the drafting is required a greater skills and efficiency. What skills? You have to have a proper knowledge of law. Knowledge of law is must. And therefore, I always tell, I teach drafting to my students in the 5th year in GNLU. My subject is drafting, pleading, and convincing. And here I tell my students, it's a wonderful opportunity to you that you can revise all the subject you have learning earlier. Here you have to study contract again. You have to study CPC again, CRPC again, IPC again, all the subject which you have studied, because without knowledge of the law, you cannot draft it, right? So knowledge of law is most important. For that you study. Apart from that, procedure. So second thing is about procedure. What is the procedure? How civil suit can be drafted? How criminal matters are different? What is bail and what is anticipatory bail? Right? What is writ petition and what is public interest litigation? There are certain different procedural aspects. So you have to keep in mind that also. Third is settle judicial principles. The judicial precedent, and we have the source of law. That precedents we consider as an important source. So what judiciary has said earlier, take example, that sexual harassment of the woman at the workplace act, the Vishakha versus State of Rajasthan judgment came, and sexual harassment became the liability of the employer. So judiciary has made it very clear. Just few days back, I was taking a session, and there's an interesting case in which what happened, that there was a matter in a university, and in that university matter, some senior students didn't harass the junior girl students, and there was some sexual component also involved. Now what happened, that when matter came to the university surrendered the matter to anti-ragging committee, and that matter went to High Court. High Court blasted university like anything. Okay, do you understand that university is a workplace where students are learning, and then any matter which is harassment should be reported to the internal complaint committee under the POSH Act, and not to anti-ragging committee. And that judgment we have. It's a M. Kamya case, if I'm not wrong. So judicial principles are there. If this kind of matters have brought, the entire petition or entire handling of the matter should be done in that way. and therefore a drafting also goes with that. So third thing you have to keep in mind, judicial thing. And finally, proficiency in English language. I have mentioned English language because generally we accept English as a accepted language for the court practice. But let me tell you, when you do the lower court practice, then there are matter in a local vernacular language also. So you need to understand Gujarati, Marathi, Rajasthani, or any local language which may be applicable to the thing. So these four things is very wonderful, the spectrum of the thing. And therefore you have to think, you have to learn the subject by heart, you have to get proper idea about the facts with the proper language. When you associate with the logic, it's coming in the good art. And this all thing is required to be learned by experience and by different kind of the practices. And therefore the drafting is called the composite art. So what qualities a good drafter should have? Number one is a good command of language. Okay, I don't have time, otherwise I would have shared some interesting drafts that you want to convey, but you are unable to put in a proper language, because see, what we speak and what we write is a drastically different. Okay, I want to simply go to the court and I want to say, yes sir, I am a petitioner and this person is respondent. He has taken custody, or he has illegally entered into my premises, and I want a blank and vacant possession of my property, kindly granted. So this is very properly oral. But when you put in writing, I will use the proper language that the petitioner is this, the respondent is this, and this kind of the thing have happened, and because of that it is violation of my this right and I want it. So good command of language in a writing is important, and not it goes without saying it should have the grammatical correction also. Clarity of fact is so interesting, so important. Most of the matters are getting disposed from the court of law because these are the clarity of the facts is not properly available. Actually, you don't know the real thing, and most of the time this is disaster. And therefore, again and again, your seniors would be telling you, in case you are a student, that get the facts very thoroughly. Actually, what is the matter? Is it a matter of bounce of the check, or is it a matter where person is denying the money received, or is it a matter where there is an illegal transaction come? What is the fact? So second thing is clarity of the fact, and therefore in legal profession we always say you have to be the master of the fact for sure. Master of law is coming later. Getting facts is very important. Third is very important aspect, clarity of law, which I already told you. And therefore you have to do rigorous training of the law. Which law? What rights? How rights are available? Generally, we take it generally for granted that okay, if this section is not taught, what is wrong? But let me tell you, this same thing is becoming very important when you become part of the justice delivery system. Fourth point, you have to have ability to arrange fact in sequence of the time or date. How you are arranging. And that's what I give example, that you can also ask the honorable judges that when they are listening to the matter, hearing the matter, they are always going chronologically. Even in High Court, there is a paper book submitted, right? So you arrange everything in chronological sequence. Originally what happened, then what happened, and that is ability. So when client is coming to you and when you want to draft, first primo thing you put a paper, or you put on paper, then 1, 2, 3, 4, 5, starting from the past and coming to the present. So that's an important ability. Fourth thing, ability to arrange the bare fact without mixing the fact and legal submission. You don't need to mix submissions and facts. You are able to see the bare facts, because it's a law, which I will tell you that law is not required to be pleaded. Only facts are pleaded. When you talk about the pleadings, law is not pleaded. Only facts are pleaded. It's honorable courts who are going to apply the appropriate law, and then they will render justice. And therefore, the bare facts without mixing law, you are able to put it. And finally, important thing is ability to discard the facts which are not remotely relevant to the controversy. However, at the same time, taking care of the not suppressing material facts. Most significant thing. If I am given opportunity, I will give 100 out of 100 marks to this thing. Now, let me give an example. You might have seen many movies, right? The movies start with the climax and goes into presence. That's the art to convey the facts to the people. But that actually really doesn't happen. Generally, we will always talk that suppose I am not liking to any person, and if I want to have a grudges against that person, if I will convey to my friend, I will put all the thing together. उन्होंने पहले ये किया था, वो किया था, ये कैसे कर सकता है, वो कैसे कर सकता है. So this is becoming the dispute. It's in our mind. But when you put it on a paper for legal dispute, you are discarding the facts which are not at all connected. And therefore, in many cases, you will find out, yes, sir, this contention is written here, but it is not remotely connected with this aspect, how it is important, how it is relevant. And therefore, discarding the fact. But when you discard the fact, you also have to see that it should not be concealment or suppression of the material fact. Are you getting? Like I gave example of the divorce petition. Again, I will say, okay, when there's a petition of divorce, suppose I am an advocate of the wife, and if that petition is under section 13 of the Hindu Marriage Act, when I am going to court for maintenance under 125 or under the Hindu Marriage Act sections of the Hindu Marriage Act, I am going to tell everything, but not suppressing the fact. So if marriage has happened, if any medical treatment is there, if there is a dispute, if there's a demand, I am going to put everything on a record. Otherwise, when matter is served to the opposite party will come out with the fact, and then the petitioner is coming into the very horrible situation. And sometimes courts are also taking cognizance that how come you are not explaining this point? And therefore, this is a very important ability of the lawyer who is going to be a good drafter when you don't want any embarrassment from court of law. I hope I am reaching out to you, right? So therefore, there are things now finally when we conclude, what are the stages of legal drafting? Quickly, in case you are willing to understand the drafting, quickly I have pointed. There's a planning stage, there's a writing stage, and there's a revision stage. All drafting is necessarily passing from these all stages. Let me tell you, if we think that we can take a help of AI, we can take help of any kind of the software, sometimes it is creating disaster. So you have to give a human touch in a drafting for sure. So I have bifurcated. Quickly, I will bring your attention that what are the three broad stages. In planning stage, what you do? First is you're taking instruction from client. I always say that a good advocate is always a good listener. Okay. When a client is coming with a matter, or even though you are not able to get the client right now, but suppose you are preparing for moot court, you are very patiently getting all instruction. And then you are writing without applying your mind. That what instructions are there. Whether client is willing to go to the court and want you to take a matter, or client is only happy to get a notice and then matter is over. Sometime, according to my observation, client is not willing to bring the matter to the court of law. They say, साहब एक notice draft कर दो, and वो notice के ऊपर से हमें उसको सिर्फ एक उनको notice देना है. That's it. There is no need to give the matter to the court. Now here, the drafting comes in a different manner, because when you draft a simple notice, that's a separate intention, because notice is not that much elaborative and extensive the way you are drafting a suit or writ petition. Okay, so you are taking instruction from the client first. This is the first stage. Second stage is analyzing the instruction and compartmentalizing the in a factual and legal context. You took instruction. Now the legal task is starting, that whether this is factual matter or legal matter. So here you take all this kind of contention, that what is the information, what is the material fact, who are the parties involved, whether it is single party or multiple parties, whether multiple parties are individual capacity or representative capacity, because facts will be like a jumbled up. No, it's all mixed up. And when you are analyzing, okay, if this has happened, I think this is the appropriate remedy for them. Let me tell you, there are chances where there can be civil remedy available, there can be criminal remedy available. I hope you are getting the point. मैटर ऐसी हो सकती है जिसमें सिविल एंड क्रिमिनल दोनों रेमेडी आप क्लाइंट को दे सकते हैं. It may be a matter where you can go to civil court because this enforcement of right is there, or it can be like, take example of the IP infringement, intellectual property disputes. Now, intellectual property disputes, you always say there is infringement of copyright, there is infringement of trademark. You can always go and lodge a FIR under the provisions of the copyright law, trademark law, or you can always go to court and file, okay, I want damages. I don't want you to behind the bars. I want damages. So you are always analyzing the issues. This is the second step which is coming. Third step, you are ascertaining the purpose and objective behind the creating document. Most significant portion, I am talking purely practical aspect, not theoretical aspect. When I am coming to you as a client and I bring the matter, you have to decide that what document you are going to create. Are you creating a notice, or are you creating a caveat? Are you creating a suit? What you are doing? That's a very, very important. And this is not written in any book of law. You have to analyze and you have to create it. And here, the experience of the advocates come into picture. And therefore, you do internship. You are always trying to learn from the practice. You are always trying to learn from the other advocates also who are going to understand about things, right? So these are the second, third step. Fourth step is coming. Research relevant up-to-date law and find appropriate forms of precedents. Suppose I give example that there is a matter. Now, suppose if I am working in the university and some matter like the ragging or a sexual harassment is coming in front of me. If I am going to be an office bearer, I also have to have a knowledge in such matter, what is the observation of the court and where I should go. So fourth level is coming at this is all planning stage only. So you are taking instructions, you are analyzing, then you are deciding what is purpose of drafting, then you are deciding what is a up-to-date law. Let me tell you, this is again a golden period for all of us, because the society and the law both are changing on a very quick manner. Just check how many laws are amended by the government, what different bills have been produced before the parliament, how many laws are there. Recent examples about the new criminal code, new criminal law only. I am sure that students who are going to study the criminal law now will be studying both the criminal law, IPC and Bharatiya Nyaya Sanhita both, because the example existing cases which are there going to be disposed under the IPC. But the futuristic, after July, whatever cases are going to be lodged would be under the new law. So it is important for us to be updated, and accordingly, according to new law, it is coming. I gave example of the POSH. I will give one more example of the POSH, that like sexual harassment, which earlier was decided and was educated by the POSH Act only. Now under the Bharatiya Nyaya Sanhita, separate section have been added about the sexual harassment of the women. So now you have two provisions available about ICC, when the matter can be brought by the women to the internal complaint committee, and in form of the crime also when it is specifically identified by the BNS. So both the thing means about the availability of the knowledge is important, which is coming in the planning stage. And finally, identifying the option. The fifth and last planning stage is that where you will go now. And here you say, what is the quickest remedy your client can get? Okay, what are the alternatives? Whether settlement is required, civil court is appropriate, criminal matter is available, what is options? So these are the 5 stages of the planning which you can do that. And if you want to see that we talk about the drafting stage, slowly, gradually you are learning in a course of the time, right? So whenever the next speaker will come, they will tell you, okay, we are drafting this document. So it is important. Okay, so in planning stage, I told, take instruction from the client as a one, analyze the instruction, then ascertain the object behind the document, then research relevant case laws, and finally identify the option. These are the 5 things. Then writing stage. Second stage is then now you are starting the drafting. So here, first of all, we are preparing the skeleton draft. And it's always the first draft, which is a combination of all the things together. Those who experience to draft would appreciate this point. Whenever we are drafting something, we always try to write again and again, and you think, no, it's not proper. So you are tearing the page and you are doing that. Once upon a time, pages were getting turned. Now you are doing everything in a laptop or in a computer. So you are always preparing the first draft, and in that you are preparing all material relevant matters are included. So in skeleton draft, it is important. Second thing is create ideas for the draft. Now skeleton draft is ready. Now you are doing more analysis, that what are the next stop, what are the important facts which are missed, and how I can put it in reference of the law. The second step is coming, and third step is sure that content received during the planning stage has been incorporated. Now you might have planned for palace, but when you come out, it should not be like hut. Okay, so that's a very important point. Okay, whenever you took information from the client and you plan that I would come out with this wonderful piece of drafting, same should also be incorporated in a proper writing. So here you are also checking grammar, you are also checking language, and you are also making the checklist. Wonderful opportunity for lawyers that when you read, you prepare the checklist. You are always creating a list ready. Then, okay, I have to add the name of the party, legal grounds, legal facts, what are the options, what are the prayer checklist, and accordingly you can put it. Last point is revision stage. Here the golden rule is you can never find your own mistake. If you have done any drafting, I am sure you would have observed that you can never find your own mistake, because whenever you write something, you always do reanalysis, and most of the time they are giving to colleagues. When I was practicing, it was a method that if I am drafting something, my friend will always have a look to that, and they will check it whether grammatically correct or not, sequence-wise correct or not, because I would be considered to be the master. I can never do wrong. That's a general impression in our mind, and therefore you are reanalyzing the instruction. You are rewriting in coherence. Coherence is very much important, because the flow of the knowledge, flow of the language should come. Okay, so whatever you have written in the first paragraph is remain constant and coherence till the last paragraph. Then reorganize the material in a clear and user-friendly manner. User-friendly manner is very important, because I always tell, you are not creating a piece of essay, or you are not writing a wonderful piece of art book where in future, like a Shakespeare's dramas and stories and different kind of the poems written by the renowned, lyricist or renowned poets, it would be read by the people and the books will be kept in library. No, it's not the case. The intention of the drafting is to get justice and to be able to reach out to the judiciary or any officer for whom you are drafting. So it should be user friendly. Most important point is coming, like, there is also one interesting practice field, like a vetting of agreements. You might have heard that advocate and experts are also giving services, that in case you want to understand a legal document, come to me, I will vet, and they will charge for that. Maximum vetting documents come in form of the contracts. I am sure, let me give a practical example. When you are using this Zoom, I think in case you are using phone, you might have downloaded the Zoom application. But when you might have done I agree, tick mark, I agree form. Now, have you seen what are the terms and conditions of Zoom? Possible, just go today and read any terms and condition of any application or any software you should download. And many times it happen that being a law student also, you will not be able to understand iska matlab kya hoga. Because we are educated illiterate. We are educated, but in legal we have illiteracy, because there are a lot of terms and lot of conditions, lot of words which are written, which are even unable to be understood by the lawyers. Forget about the common people. And therefore, litigants, who is a party, should be able to understand, as well as the judges. So that should be the proper language. Then edit the material and concentrate on spelling and grammar. If you do that, revision stage gets over. So these are the 3 stages. 5, what are the fundamental rules? You can always note down. The every pleading should have facts and not law. I will give example. Suppose you are drafting a suit, civil suit. And suit is, I gave certain money to my friend and then he is not returning back. So suit is to recover my money back. Now here, the person would have given me promissory note. Now the promissory note, I am going to put it. So my suit will be very common, that I lended the money on so-and-so date. This money was given for this purpose. Against this money, the person has given me promissory note. Promissory note was dated so-and-so. As per that, he has to return the money, but the money has not been returned. It's a failure of the promise. So this honorable court should pass a decree that if he should give the money to me, and in case he is failing, I can recover the money by selling his assets. That's a simple thing. Now here, I am not able to put it, okay, according to this judgment, court has filed this kind of judgment, according to this section of this law, I am entitled. That thing never happens in case of the pleadings. So there is no need to apply the law in a pleadings. There is requirement to facts. And that's what I told you. It's about honorable judges to apply the appropriate law and to give you justice. Number 2, it should be relating to material fact only. So material fact only relevant. There can be multiple things, like this example which I gave. The person would have taken money for multiple purpose. He would have purchased so many things. Now, suppose I give example practically. I told you, okay, I want to file a suit for recovery of money. Now I am writing that person has purchased, say for example, Scorpio car from the money, and I am here traveling on my scooter. How he can purchase the Scorpio car? It's absolutely illegal. It is not in form of the law. It is violation of the friendship right. These are the immaterial facts. Court is nothing to do. Why you gave the money and what money has, how you have used the money, that is becoming irrelevant here. Relevant point is whether he promised to return money on certain date and whether he violated the promise. That is material and that should be pleaded. Are you getting? So that's what you have to be very important, and therefore this comes as the practice. Number 3, it must state only facts on which parties pleadings relies and not evidence by which they are able to prove. Very important thing is this one. Generally, one question is always asked by the student or the people who are willing to get justice. Okay, what is the proof of that? In a pleading also, you never plead evidence also. Suppose if I carry forward the example that if I have given the money to someone and I have to get it back, I will simply put documents as supportive documents. That this is the list of document which is proving that this is the proof he has taken money from me. This is the proof he promised the money to return, and this is the proof he has not returned. That's it. Now there is no need that you reaffirm the evidences. These evidences are used when your arguments are happening. So court will read the evidence in their own way and they will be able to give justice. And finally, it must have the facts concisely, but the precision and certainty. Concise and precision. Therefore, sometimes the drafting is also précis writing. There are 100 things have happened. Out of them, you select top 10 and all top 10 things you arrange in a top 5, and therefore you go in front of the court. And therefore, these are the fundamental rules of pleading you can always keep in mind. Concluding the discussion, this is the very important portion. The drafting skill is a non-intervening skill. Please keep in mind, my dear friends, always. Do you understand what is meaning of non-intervening skill? Many times, this may not be liked by many legal experts. What I mean to say is, it is completely not with the help of the lawyers. A lawyer is not supposed to add contents which is not required for the petition. Client submission and facts are only required in legal language, and therefore the speedy justice will always come from the non-intervening skill. Now, what I mean by this, I will give a small example. The example I gave, I am a money lender. That person is a receiver. He has not returned money to me, and therefore I am coming to you as an advocate, help me. Now, primarily listening to my contention will say कि अगर इतना सिर्फ ड्राफ्ट करोगे तो आपको कोई बेनिफिट नहीं मिले, एक काम करो, कुछ और लिखो. And sometime, with due respect, there are examples where things which actually have not happened have been given into the pleadings by the lawyer. You know, they have added certain special spices, and because of that, जब उसका मैटर चलने में आता है, when court is going to have a cross examination, client is unable to remember that actually it was, because when there is a truth, there is no need required to be learned up, right? If something has happened really, client will come and he will depose. But because something extra written by the lawyers, something extra which is added, which has not connection with the actually happened facts, and therefore in aspect, and therefore I have mentioned it's an ethical aspect also. In all the students also learn the professional ethics. This is one of the important portion of the professional ethics. You are not doing, you can always prepare the client when cross-examination is happening. You can always make them aware and make them comfortable that in case if the court is asking some question, if opponent lawyer is asking the question, how to be firm and how to be the honestly able to answer. But when you are adding, and this is an example, that most of the time when petitions are there, which is completely different than what actually has happened, it is again get a derogation, and ultimately it is adding more the things. So these are the important aspect about these things about the drafting. So quickly I will summarize what has been discussed. Number one, the meaning of drafting. It's about the outline of the document. Whenever you are able to put something, what has happened, you are putting on a paper. It is a linguistic aspect. So law, which is put on a paper, it's called drafting. Now there are multiple types of the drafting. One is a informative drafting. One is a persuasive drafting. Third is a functional drafting. We started with the functional drafting, that you want to carry out some function. You draft agreement, you draft will, you draft sale deed, you draft mortgage deed. So that is all convincing also. Second is persuasive, which is a subject matter of this entire workshop for convincing the court about the one party. And third is informative drafting, where you simply inform to the people. It's a legal opinion, public notices, different kind of notice. Now you say to property dispute, you are informing that it is hereby informed that he was working as a partner with us. Now he is not more working with us. So kindly don't do any transaction with him. So you are simply getting information, informative drafting. Then what is the history of pleading? How pleading came, that we discuss. What are the types of the pleading? So suit, written statement, affidavit, rejoinder, surrejoinder, then writ petitions, public interest litigation, affidavit in response to written statement, or affidavit in reply to the writ petitions. Then the criminal matter, criminal complaint in form of FIR, criminal complaint to the civil criminal court. Then different kind of the say for example charge sheet drafting is also there, which generally done by the police department. And futuristic aspect and appeal from order, review petition, revision petition. This all things come under the pleading. Earlier it was oral pleading, but then there were a lot of miscarriage of justice. There was no possibility of keeping record, and therefore in 19th century onwards, the record keeping matter came. And today we have statute in form of the CRPC, IPC also. Now it's a Bharatiya Nagrik Suraksha Sanhita, which is giving you that your pleading should be in form of the writing, and it is helping the court. And the golden rules of pleadings we have seen, the planning stage, writing stage, and revision stage. And finally, we concluded that it's a non-intervening skill. You are not supposed to add something from your part, but you can always help the party. You can always help tell the people to come out. So if there is a good drafting, it's a good pleading, it can always help you. So these are the things. I'll share this presentation to all of you so that you can always have a look to that. And if you have any other questions, query, I think I was invited for introduction. So this is the broad introduction. In case now you are attending the sessions, you will always go a little bit deep dive and you can always say, but I always tell a good drafting, good pleading not only help the parties, but help the society and the country also. Why? Because if there is a to the point drafting which help the judges to come out with a judgment very soon, and that's in precise manner, it's a great help to the human being and the litigant society also. So I'm sure you are all here dedicating your time and energy of 15 days to be be soldiers of justice, learn drafting properly, which not only help you, but also help the petitions. That's end of the discussion. Let me know if you have any question, query or something, you can always tell me. Thank you, Kalpesh sir. Over to you, sir. Yeah.
Yes, thank you very much, sir. Participant, any question, query, you can thank later, but because otherwise the message will, question will go up. Any question, participant, you can raise your hand. We will unmute you. Sorry. Yeah, we will get PPT. Okay, no problem. Let me unmute some participants. So, okay, there's a question again and again. I can see, sir, how to improve legal language vocabulary. Yes, so yeah, your
the test is
experience.
only one, sir. That reading more and more. I always tell when I discuss the drafting in my class, I always say, do you know MC Mehta's judgment? There are plethora. Even Kalpesh sir has come out with the compilation also. Selected judgments on MC Mehta. But imagine that what was the original writ petition filed by the MC Mehta and what wonderful word he would have written that could have convinced justice that now this is actually the right to environment is a matter of right. So when I would find out the petition and I will read it, it will always help me that how the petition has been read. So legal language is always understood by the wonderfully drafted petitions. So you have to read the petition. There are wonderful judgments in which even some of the paragraphs of the petition are repeated, and practice is only the key to understand the legal drafting.
Okay. Next, Advocate Milil. Will you able to take 2-3 questions because already it's 8:50. Sorry. Yeah. Yes. Advocate Milil.
Yes, sir. Any question for me? I would love to answer. Yes.
Next, otherwise, Archie Jain and then Samriti Chauhan. Archie.
If we make it non-intervening,
बोलिए.
Yes, sir. Yes, sir.
Then how can it be? We need to make it aggressive.
Exactly. Sir, it is in reference that many times it is observed by judges that the things which are not corrected in facts, something which is actually not has happened, and it has actually. So aggressiveness will always come with the help of the words which is connected with the matter of right, that how it has been connected with the right, what can happen with the violation of the right, how the matter has been seriously impaired the legal rights of the person. So in that way it is available. So intervention in the word, that there is no need to teach something which is not actually has happened, and in order to aggravate the matter for which client is not able to depose in a court of law. In that sense, I gave examples.
Got it. Thank you, sir.
Thank you, sir.
Next, Archie Jain, and then I don't know the name. S is written. Archie, over to you. We'll take a couple of questions, then we have to close. Archie. Archie Jain.
There is a question, sir, that evidence cannot be played. Yeah, evidence. Like when you will study that when you draft petition, there are two different examples. When you draft a petition pleading in lower court and high court. In high court, lower court, all lower court CPC civil suit, the CPC provisions are applicable. So then you have to draft the plaint only, and then evidences you are putting in support of the document, and you are simply doing that. I did a transaction, and evidences have been supportedly attached with that list. But in high court, when writ petitions are filed, you will find out the rule of CPC are not strictly applicable to the petitions, be it writ petition or PL, and therefore law also come out with the detailed draft. Again, there is a judicial observation that whatever you are submitting, submit by virtue of annexures. So when I showed the evidence is not required to be pleaded, means there is no need of interpretation of evidence. That this document very clearly shows that the money was given. That word is not required. There is only one sentence you are mentioning in a crisp manner that money was lended, supported evidence, annexure 1. That's it. So there is no need to interpret and elaborate the evidence. That's what I told about which is established law about the pleading side.
Good evening, sir. Am I audible?
Good evening.
Yes,
Yes,
audible.
yes,
Yeah.
yes.
Sir, I have two questions. First, I would like to ask what is informative drafting? And second, can you please suggest some books regarding drafting and pleading?
Yes, yes. I told informative drafting comes in form when you do legal opinions, right? Like suppose you do title search. So you title search report given by advocate. Public notice, you take example that every time you are informing, like I am a friend of mine and we have startup. One of the person is now absconding. So I inform to the people, okay, don't do transaction with them. Now there is also requirement of drafting. There are corrigendum, there are tender notices. Now these things are not part of the court or it is neither convincing. It's kind of information to the people. So in that form, it is following the informative drafting.
Okay, thank you, sir. And can you
Okay.
please suggest books for drafting?
Yes, yes. Yes, yes. I will share the couple of books. I don't know whether it will be available in library or not, but there are general books which are including good amount of drafting, good amount of drafts and fundamental principles. So I will also try to share some good references which are there, and Kalpesh sir will forward it next forward to your group.
Okay, thank you, sir.
Thank you.
Next, Prashant Saxena. Sorry, we have to. Actually, we won't be able to take so many questions. Otherwise, it will.
There is a question how we can read original petition. Now, sir, there is an interesting thing. Original petitions you cannot find because we get judgment only. So either as an advocate, when you get a certified copy, so suppose if you want to read the petition, you go to court and you file certified copy application. So when you file certified copy application, it comes with the petition also, it comes with the written statement also. Otherwise, nowadays people also you right to information application. So court judgments and detail. And third point is very clear, when you are practicing in court of law and when advocates have put the matter, you can always get it. That can I get the petition to read, and accordingly you can get it. These petitions are not coming in judgment. It is always submitted to the court of law, but once it is submitted to court, it becomes public document. So you can always get it by certified copy, by RTI, and accordingly you can read it. This is something extra you have to do. But when people want to learn, they always go to the extent and can get it.
Next, Prashant Saxena. Please be very fast. Prashant Saxena. Or next, Sumit.
I
Sumit.
think they have put their questions here and there.
Yes.
Hello, sir.
Yes,
Good evening, sir.
Yes,
Am I
yes,
audible?
good evening.
Good evening.
Yes.
Sir, just as I would like to share one thing about intervening. My cousin is reeling under a marital case in which the opposite lawyer is, putting up all sorts of allegations of dowry, also domestic violence, also, and these things keeps happening in these domestic cases, sir. The
True, true.
lawyer says that to increase, the pressure on the client, it does that.
Correct. So what happens here is, like if we also have seen a lot of matters. There are allegations. When it is applied and when it is responded, the defendant is simply putting these allegations are not correct and true, and it is required to be proven. That's it. So when there are fault allegations are put, the person who plead have to prove. The rule, golden rule is also this. Okay, when whoever is speaking have to prove in a court of law. So when I, as an advocate of the wife, is putting allegation that my client was beaten, the responsibility come to my shoulder that I will put a medical evidence in support of that. If not, the husband's advocate will come say it is absolutely wrong and that is not proven. So court will never understand this also. So court now also have find out the way that this what you are telling is absolutely correct. Nowadays courts have also understood the gravity, and therefore whenever you are defending this kind of matter, it is always denial. Denial is the best solution to the problem, and accordingly the matters are dealt with them.
Okay, so last question. I
Right.
think, sorry, we won't be able to take much question. Last question from the participant. So impact of AI on drafting. It's really available. Impact of AI on drafting.
Yeah, AI is a very interesting portion. Again, I told you AI is helping you by templates. But be very clear, in case you want to take example, just use any AI software and draft. Tell them to draft a petition. The petition would be very basically, because the AI is also using the existing knowledge available on the websites and on the cyber space. Generally, good draft is always, because drafting is all about human intelligence. Artificial intelligence is not able, because judges are also human and we are also human. So AI can help you to have structure, to have some words to replace the word. Like suppose I want to draft a original initial para, I can always get it verified by the AI. that it can be drafted, rephrased. But ultimately, prayer grounds is always coming with the human. It's always better to use the human intelligence so that you can effectively reach out to the judges. Because the purpose is very simple. The judge should understand what you are claiming. Now, he will not ask, okay, you have to draft the para in a very artistic way, in a 100 words, that how you are going to be petitioner. That's not relevant. And therefore, AI can help you, but not in complete extent.
Thank you very much. Sorry, participant. I think
Right.
I can
All
see
right.
there are 15, 20 questions are there. Sorry, we won't able to take. So thank you, sir, for
Then
your
you can
sharing a
put it
value.
and you can get it later on whenever you forward it to me. I would love to share, and most of the things are about writing. So we can definitely get it further, right?
Definitely, yeah. Participant will be sharing PPT other material received from sir as soon as possible. And then thank you, sir, for sharing a valuable time and then setting a stage for, it was very important, I would say. That's why we put up, theory also needed, right? To directly jumping on the drafts, not necessary, right? And then I can see some participants, first year students. So don't worry, you will learn this thing, gradually. Start reading some things, there are practitioner and some law student, they'll be learning in the final year of, their curriculum. So I learned, it's a practice thing. It's what we are doing. It's giving you, just thoughts, right? What to do, right? And saving your time, right? Before you are entering into right professional career. So what we wasted, I would not wasted, I would say. There's no particular, it's Dr. Hardik is also offering this advanced legal drafting, because it's very difficult to cover all the drafting in that drafting and pleading paper in our law school. So that is again the advanced effort, I would say, from his side. So elective paper and many students and also part of a couple of lecture on RTI. So I have not mentioned in our schedule, right? So I'll be taking whenever I get time in this particular program on RTI drafting. So with at least stated, you can get those documents from RTI, from filing RTI or appeal, maybe if needed. So thank you, sir. On behalf of organizing committee, I'm grateful to you for sharing a little bit time and then setting a stage for our future the sessions that lined up for next 15 days. Thank you, sir.
Thank you
Look
so
forward
much
to
for
it.
calling me and spending time. Thank you so much. I will meet you
Thank you,
again. Thank you.
sir.
Thank you. Thank you.
Thank you very much. So thank you, Viranshi, all the team and the participants for joining. So we'll be joining tomorrow. Timing will be from 7 to 8:30. So we'll be keep informing all the information via WhatsApp group. Good night. Thank you very much.